Good morning, everyone. Good morning, everyone. Let's try again. Thank you. It is truly an honor to welcome you to this session, Judicial Advocacy Under Attack, the Role of Courts in Preserving Rights. As a human rights lawyer, a woman, and as someone deeply rooted in the community, since I migrated to the United States from Colombia at the age of 5, I have seen firsthand that the courts are not just a branch of government. They are the foundation of our democracy. They are the baseline. They are where the promise of our Constitution are tested, upheld, or sometimes eroded. When we think about democracy, we often picture elections, legislators, and movements in the streets, and all of those are very important and they matter. And in the courts, this is where our laws are measured against our values, where principles like due process and equal protection, freedom from discrimination, where they're turned into real protections for real people. And it is here, case by case, that our democracy faces its truest tests. Will power be checked? Will rights be protected? Right now, we know that those tests are coming faster and harder than we've seen in decades, maybe even ever. Take the Supreme Court's emergency docket. Once rarely used for any major policy changes, it's become a key tool in immigration litigation, with more than 50 immigration-related lawsuits against the administration still pending. Trump v. Casa as an example. On the surface, this case is not about immigration enforcement, but at its core, it's about the expansion of targeted immigration enforcement through executive power. And cases like these reveal something deeper. Constitutional rights, particularly for communities of color, are under attack. These aren't just legal battles. They're battles over the very meaning of rights and whether our democracy guardrails will hold. This is why judicial advocacy is so essential. It is our tool to challenge unsuccessful actions, to defend the most vulnerable, and to ensure that rights promised on paper are lived realities. It is our system of accountability, reminding those in power that they too are bounded by law. For lawyers, that means building airtight cases and using courts strategically. For community advocates, it means bringing forward the voices and evidence that shape the law. And for our LULAC Academy students and youth here, it's proof that the law isn't some distant concept. It's a tool you can use to bring real change. Today, we are joined by extraordinary leaders who live this work. The Honorable Raúl Torrez, Attorney General of New Mexico, showing how state leadership can safeguard rights when other systems fail. Thomas Saenz, President and General Counsel of MALDEF, whose landmark cases have shaped Latino civil rights for decades. And guiding this discussion is our moderator, Ambassador Norman Eisen, co-founder and board member of State Democracy Defenders Action, whose deep expertise in constitutional law, ethics, and democracy protection will help us examine the judiciary's role with clarity and urgency. Let us remember, courts are not distant. They are living parts of our democracy. They are a safeguard we must defend, a tool we must use wisely, and a place where justice can prevail, if we are willing to fight for it. This is about law, but it's also about power, equity, and the future of our country. And it's about each of us, whether lawyer, advocate, sponsor, or student, understanding our role in keeping the courts that strong, unshakable foundation of our democracy. Please join me in welcoming our distinguished panel.
Thank you, Alba. I'm Norm Eisen, and among all those jobs I've had that Alba referred to, White House advisor, ambassador, founder of democracy organizations, there's no job I've ever had that I'm prouder of than being one of the outside counsel to LULAC in your legal fight to defend the Constitution, Latinos, migrants, and all Americans and the American idea. I want to, before we jump in with two of our most distinguished legal fighters in the country today, I want to thank Alba. I have to say some words of acknowledgement for the wonderful president of LULAC, Ramon Palomares, CEO Juan Proano. I speak to them, one or both of them, almost every day about some of these cases that we're working on together and these wins that we have. We're very fortunate to hear from the Attorney General and from Tom today about the situation. The title of our panel is Under Attack, the Role of Courts in Preserving Rights. I think that title was intended to refer to the Trump administration's attack on the Constitution and rights, but the courts have mounted a furious counterattack to protect our Constitution, and the two men who are with us today are leaders in that effort. Between the time when we put the panel together and invited the guests, and today we have had two major new attacks that I'm going to start with. The first is the effort to take an already odious, and Tom, I'll come to you on this first, the effort to take an already odious, terribly gerrymandered Texas congressional map and to make it even worse, even more obscene, by stealing 5 more seats, as if it wasn't bad enough already. And that brave Texas delegation, over 50 of those legislators who are fighting back with the power they have to say enough is enough. Tom, what is your reflection on this outrageous assault, latest outrageous assault, in light of your redistricting litigation, and what can be done about it?
Well, Norm, I think you're absolutely right to start with the case, because what the Texas legislature is attempting to do is to override our judicial system, to take it out of the picture, to eliminate its role of protecting the voting rights of everyone in the country. And it is doing that in 2 ways. First of all, the effort is undermining the ongoing litigation challenging the current map, which is still happening. Just went to trial a few weeks ago. Trial has concluded, but post-trial briefing is still happening. That won't be done until September 3rd. So even while the state of Texas and MALDEF and a number of other organizations, including LULAC, have spent years preparing and presenting a case challenging the existing map, that threatens to be overwhelmed entirely by a new map to be adopted by the legislature. So circumventing all of that effort by the judiciary as well, because as you know, Norm, that case involves 3 judges. Statewide redistricting constitutional challenges get you 3 judges hearing a trial. So a lot of judicial energy expended, all that goes out the window if the legislature is allowed to act. But perhaps more egregious is they are acting at a time so late in the calendar with respect to 2026 elections that they are attempting to prevent any court anywhere from reviewing the new lines in time to prevent them from being used in the 2026 elections. Now, in my view, that's straight up unlawful. You don't get to circumvent civil rights law, especially the very much esteemed Voting Rights Act, by acting so close to the election that you prevent any court from meaningfully reviewing what you have put in place. That review would be essential in this case, because in order to achieve the partisan aim that you've described of 5 more Republican seats, they will threaten Latino voting rights in the state of Texas. They will create what are on their face majority Latino districts, but that are unlikely, based on past historical evidence, unlikely to actually result in Latino voters' selection being the one that is elected. So that undermines the Voting Rights Act. They have to do that in order to gain these seats, and they are doing it in a way to try to prevent any judicial review whatsoever of whether their lines can go in effect under the Voting Rights Act before 2026. So in many respects, it is a dangerous and unprecedented attempt to eliminate the third branch of government, the judiciary, from playing its essential constitutional role.
Tom, you're not going to let them get away with that. Neither am I or all of us here at LULAC. I'm going to come back to that. To General, I'm going to come to you next because on Tom's exact point, the necessity of judicial intervention and the effectiveness of judicial intervention, the attorneys general and New Mexico has been a critical part of this, have filed more than 30 cases with an absolutely outstanding winning record in these first 6 months of the Trump administration. And at Democracy Defenders Fund, we've been very privileged often to litigate in tandem as you and separately we on behalf of LULAC won injunctions against Trump's elections EO to steal votes, or fought his birthright citizenship EO to discriminate. All babies born here are citizens under the Constitution of the United States. You and we won court orders saying as much. The AmeriCorps case, we've also worked in tandem. Many, many others. Will you talk to us about the fighting spirit of the AGs, why and how the AGs, out of all our government officials, you've been on the cutting edge of pushing back and fighting and winning. Such an example to all of us. Will you talk about that strategy and the accomplishments you've achieved?
Well, first I want to thank LULAC and I want to thank everyone for giving us an opportunity to talk about this important work. But I want to take a step back from the specifics of some of those cases that we've been engaged in and focus on something that I think everyone here can relate to. We talk a lot in the work of attorneys general about promoting the rule of law, about defending the Constitution, about upholding the institutions of our republic in ways that are often abstract. So I want to try and make it as real as I can for everyone here. My belief is that the story of this country is a story of an unfinished project. It's a project that involves closing the distance between what we say about who we are as a people in the Declaration of Independence and in the Constitution, these lofty ideals, these lofty proclamations about all men are created equal and each of us are endowed with certain rights. But we know, and the people in this room know, that what we say about ourselves and what is reality is not always true. And so our job as advocates, our job as attorneys, our job as voices for communities who have been left out is to close the distance and to make sure that we hold this country to account, not for its failures per se, but to hold up a mirror and show everyone in this country of who we can be and what we're capable of. And so I say that as somebody who comes from a family, probably like many of yours, who was legally, systematically excluded from full participation in the full rights and citizenship of this country. And we're not the only community that has experienced that. I remember vividly stories of my grandparents who would travel from New Mexico to parts of Texas, and they would have to sit in segregated restaurants, and they would have to sit in specific parts of movie theaters, that they weren't allowed to fully participate in those things. And this is not a story that's unique to our community. The reason I bring this up is that this is not the first time that we have lived through an experience in America where we have had national leaders who have been dominated and motivated by fear, who have tried to point the finger and to blame others. And we are used to that fight and used to that struggle. What is new is that we now have people in positions of authority with real legal authority and training and an understanding of the system that allows us to navigate this space in a way that brings a full accounting to the distance between what we say about ourselves as a nation and what we actually do as a nation. And that's our job. At the end of the day, Mr. Saenz and I are engaged in litigation, and what we are doing is preparing a record, a history of this moment in time to hold up to America. And if you look back at the history of this country in the Plessy v. Ferguson and Korematsu and the Dred Scott decision, there is a long line of cases that live in infamy in the Supreme Court, not because they got it right, but because they got it wrong. And for those of us who have had the privilege of going to law school and learning about the law, we hold those moments up as signposts in American history of how we got off on the wrong path and how we can turn things back again. I don't know how this ends. I'm extremely proud of the fact that we are winning nearly 90% of our cases in the district court in this country. But the story will not be complete until we have a reckoning, a full accounting in front of the Supreme Court. And given the composition of this court, I don't yet know how they will rule. But I have faith in one thing that unites us in this work beyond this moment, and that's a commitment to the idea that what Dr. Martin Luther King used to say is the arc of the moral universe is long, but it bends towards justice. And we may not get the decisions out of the Supreme Court that we want right now, but we're putting down a record. We're holding ourselves accountable to the American people and to history, and I have faith in this country, and I have a faith in this community, because here's the thing. I talk to people all the time who are terrified. They're right to be terrified. It's understandable to have anxiety and fear. But we've been through this before. We've been through more than this in the past. And we're going to get through this again. And the most important thing for everyone here to understand is that the work that we engage in the courts and on your behalf is essential to providing some true north, some direction for this country to follow, so that this is a nation that actually lives up to its ideals, and that's the work that we do each and every day.
Thank you, General, for informing the perspective that lies behind the extraordinary effort of our AGs to protect and defend us all. And I think history will look favorably upon that. I will say that as we grapple with this Supreme Court, Tom, I'm going to come back to you next. A coalition of people at Democracy Defenders Fund, we're very honored to represent the city of Los Angeles in this case. A coalition of litigators in Los Angeles secured an injunction against some of the worst excesses of ICE. We have that injunction in place. And the Ninth Circuit, it went, as so often happens, it's the case, it goes from the district court, it goes up to the Ninth Circuit. The Ninth Circuit withheld the injunction. But Tom, apropos of the AG's reflections about this Supreme Court, that case is now on the shadow docket at the Supreme Court. And many of the 90% of the cases that we've won are the ones that haven't gone up to the Supreme Court. They've been so profoundly compromised. Can we have any confidence, Tom, that they will protect us all from the worst abuses? And it's not just undocumented migrants. It's American citizens who are being detained and abused. And we documented that in our case. We've put a stop to that. Tom, how do we make sense of this Supreme Court, and can we have any confidence that they'll do the right thing here or elsewhere? Such a clear-cut case until it gets there.
I think we have the greatest lesson that we could ever hope for about the critical importance of judicial nominations. And every time we vote for a president in the future, every voter should have that in mind. Because what undermines our confidence in this Supreme Court is not just this experience of the abuse of the shadow docket to take preliminary injunctions and prevent or limit them from going forward. But we basically have a court that has far too many justices with an ideological agenda that is not consistent with past decisions of the court and is not consistent with long-term understandings of the Constitution. That is what undermines our confidence in even the most basic legal propositions. The case that you are talking about in Los Angeles, that MALDEF is not a part of, but obviously observing from the side, and we are representing US citizens in other actions, is a very clear-cut case of folks engaging in unconstitutional conduct. Now, in part, they think they can get away with that because they are targeting the undocumented. But we rely on a Supreme Court recognizing that when the Constitution says person, in the terms of every person shall have a right of due process, for example, the persons includes exactly what it means. And one would think that textualists, original intent adherents, would recognize that person means person, and undocumented folks are persons. Now we have an unfortunate narrative that has a long history in the Latino civil rights community of folks like the state of Texas as long ago as 1954, and the first Latino civil rights case to make it to the Supreme Court, Hernandez versus Texas. But states like Texas contending that somehow undocumented immigrants are not persons, quote unquote, under the Constitution. That's back in 1954. And just this week, we have a president of the United States who seems to think that the census, which is supposed to count all persons, does not mean counting certain immigrants. So there's a long history of this ideology that should have no hold in the Supreme Court. Unfortunately, we know that there are at least 2 justices who in all likelihood do adhere to that ideology and do everything they can to pursue it. But in the end, Norm, I think you would agree, the Supreme Court is an essential bulwark, that there is an extent to which the Trump administration goes that is beyond anything that would be acceptable to at least 7 of those justices. But we can influence that, because those who think these justices act in an ivory tower with no influence from the outside are mistaken. They all have clerks. Their clerks read what's on social media. Their clerks read what's in the media in general. And it informs what they tell justices may be possible or what would be a step too far. We have to work to change the common wisdom to align with the very unexceptionable notion that person means person. And there's still work to be done in that regard. So I understand the lack of confidence, but we are not powerless in increasing our confidence that even this court will get it right. Again, I'm putting aside at 2 justices who I think you can't reach no matter what. But we still have power to change our level of confidence, and ultimately, as the Attorney General mentioned, history is going to change the bad decisions. But that happens quicker if we remember the lesson that judicial nominations matter and matter critically in every presidential election.
Well said, Tom. General, I want to come back to what you said as we think about the Supreme Court. The pro-democracy coalition, the AGs, the outside litigating groups, LULAC, which has been very active in these first 6 months, have had a 90% winning record. And many of the cases you've won have been so clear-cut that even the Trump administration hasn't tried to get them to the Supreme Court because, as Tom says, at least 7 will smack, as bad as they are, at least 7 will smack down the Trump administration. One of the big wins that you have enjoyed there has been parallel LULAC litigation where we represent LULAC, and in fact, our case is known as the LULAC case. You are the lead plaintiff in that case, and the AGs are litigating separately, is Donald Trump's elections executive order, where he tried, and so far you stopped him, and you stopped him from breaking our elections. Will you say a word about that case, what it's about, the strategy, and where it's at today?
Well, fundamentally, what you're witnessing in the second Trump administration is an attempt by this president, with the backing and acquiescence of his Republican allies in Congress, to consolidate as much power as possible in the executive branch, in the presidency. And what they have done is taken a systematic approach to not trying to thread the needle on any one of these legal doctrines, but to blow past any of the guardrails that have been established. And it's worth noting that none of his predecessors in his own party, be it John McCain, if a President Mitt Romney, for example, or George W. Bush, or any of these others who were either presidents or nominees of the Republican Party, none of them would have dared to grab as much power and disregard as much established law as the Trump administration has clearly done in the first 6 months, 7 months of its administration. And part of the key ingredients of that is to seize the machinery of voting, to seize the machinery of democracy, to take over and to assume control over, or to try and intimidate state-level elected officials in their core responsibility in the administration of justice. And one of the things that folks should understand, and I know it gets complicated, but one of the features of our government that protects our liberty is the division of power, not just between the 3 branches of the federal government, but the federalist system between state power and federal power. There's a reason that the founders empowered states to administer elections and to have control over that, because it's a way to break any one person's grip on that machinery of democracy. And so some of the executive orders that have been issued, including the ones that we specifically challenged, attempt to seize control over and take control of the election system by setting out specific requirements of how clerks in the various states go about doing their work. This is something that, as Norm pointed out, is, again, clearly in violation of established law and established precedent, something that we're very concerned about, because, as you can imagine, if this person were to be able to empower federal agencies to intrude on the power and prerogatives of local officials, that's one more element in their long-term strategy to try and undermine the independence of states and the ability of people at the local level to ensure that there is some check and balance against the encroachment of the federal government. And so that is something that we've been actively engaged in. It's also something that we expect to be accelerated in a number of ways. And I'll give you one very important example that we're very closely monitoring. There was an executive order to establish English as a national language. In New Mexico, by virtue of our history and how we came into the United States, our Constitution guarantees our citizens the right to full participation in the administration of government in both Spanish and English. And so our concern has to do with the availability of Spanish language ballots and Spanish language government services to enable people to have full participation regardless of where they come from and what language they speak. And that is an essential component of the American experience. And it's also a fundamental legal promise that was made to the people of my state, but also a promise that is available to all Americans. There is no language requirement to be a citizen of this country, full stop.
Norm, if I could just, I want to make one critical point in addition to the important point that the Attorney General has made, which is what everyone in the room knows, but I think we need to acknowledge, which is these attempts to undermine democracy through the executive order and otherwise are entirely about the Latino community. They're entirely about the fact that when Texas flips, as a result of the growth of the Latino community, and I know you read constantly about how Latinos in Texas are voting more and more Republican. That's true for the president in certain regions of the state, but not the majority of Latinos who live in urban areas. So when Texas flips, it's game over for Trump and his party for the foreseeable future in this country. And they know that. So this threat to democracy is entirely about suppressing and deterring votes in the Latino community, particularly in Texas, but everywhere in the country. They're not going to have much success in states like New Mexico or California, right? But they are going to have success in states like Texas and Florida, which are critical. Texas, the most important. But this is entirely about the growth of the Latino community. So the assault on immigrants targeted almost exclusively at Latino immigrants, and the assault on citizen voters through efforts to suppress democratic participation, perfectly legitimate democratic participation, to suppress and deter participation by folks with every right to vote, all in the name of non-existent, completely non-existent voter fraud in the Latino immigrant community. This is all part of one effort to prevent the inevitable increase in power for the Latino community that is viewed as a threat to Trump and his followers.
On that point, I'm going to ask one last question, then we'll have each of our speakers sum up for 2 or 3 minutes, and we'll end at 45 minutes past the hour, keeping the conference on track. Tom, you alluded to this. The other signal piece of elections theft targeting our black and brown communities is Donald Trump's announcement, despite the Constitution saying that we have a census, which is used, among other things, to set our congressional districting and redistricting. We have one every 10 years. It says so very plainly in the Constitution. But that's not good enough for Donald Trump, who's facing electoral retribution in 2026. And we just finished the last one about 4 years ago. Says, no, we're going to do another one. And we want it to be done before 2026. If anybody has any question what that's about, he is trying to take away votes from brown and black voters and to stave off the landslide that is coming. And we're very proud at the Democracy Defenders Fund that LULAC has asked us. As soon as that announcement was made, Juan and Roman called me. They said, start your litigation engines, Norm. So we are already drafting and will work with the wonderful coalition and represent all of you to fight that if necessary. Tom, thank you. Thank you. It's nice to be with all my clients. I should point out that it takes a village. My wonderful partner in so much of this work, Jonathan Diaz, is here from CLC. You'll hear from Jonathan in the next panel, and many, many groups working together, including MALDEF, which has been such a terrific fighter in the last census round. So, Tom, I'll give you a word. I'll give the AG a word on this census threat, and then I'm going to ask both of you to sum up.
Well, again, it is clear that the target here is us, to remind us all in the 2020 census, when Donald Trump was president of the United States, as a result of all of the publicity around his apparent willingness to violate the law, including potentially the law with respect to the confidentiality of census records, coupled with all of the attention given to his attempt then, through Lyon Wilbur Ross, the Commerce Secretary, to add a citizenship question, ultimately prevented through MALDEF and litigation and other litigation. We had the largest undercount of any racial ethnic group in the country, nearly 5%. Only a subgroup, namely Native Americans residing on reservations, had the same undercount of nearly 5%, higher than any other racial ethnic group in the country. That was by design, and because that didn't work, despite that undercount, to remind us all, Latinos accounted for 51% of all of the population growth in the entire country from 2010 to 2020. So despite a huge undercount, by design, still 51% of the growth. Since that didn't work, now they will try every other effort, including a status question that they want, try to make sure that the census undercounts us even more, recognizing the threat that the growth of our population, as I argued earlier, presents to them. Now, this latest announcement, completely disrespectful of the Constitution, completely disrespectful of the law. But also, I need to note, it's important to be prepared, as I know Norm and his team are. But diversion is a tactic, folks. Diversion is a tactic. And the president's announcement is ridiculous. There will be no census before 2026 elections. There will be no census that excludes immigrants before 2026 elections, or indeed any time before 2030. And I think we need to recognize, be aware, be prepared, but diversion is a tactic. And we need to focus on what is the direct threat today. Well, direct threats, because under this government it's so many of them, when we hear these ridiculous announcements. Arguably it's diversion from Epstein. Arguably it's diversion, frankly, from the other things that we can and are challenging on a daily basis.
I can't believe you worked in the hidden Trump-Epstein files cover-up into our panel, Tom, but bless you for that. General, I'm mindful of the clock. I'll ask you, please, to offer us a reflection, if you like, on the census threat or diversion, as it may be, and then to give us some concluding remarks.
So, I think Tom summarized the census issue pretty well. I agree. I don't think this is something, Donald Trump wakes up and there's just no filter between, right, brain and mouth. So he just rolls out of bed sometimes and just says whatever pops into his head. He'll be prompted with a question, and maybe he'll come up with something a little bit provocative, and then he'll throw in, we'll have to see, or I don't know. Maybe we'll look at it, maybe we won't. And that's a way to keep people, as Tom said, off balance. I tend to think that the census issue is something that is more distraction than anything else, but it's something that certainly we have to be mindful of. But I think the more important point is the one that Tom raised at the very beginning, and that is simply this, and something that I'm sure has been a topic of conversation in this organization for as long as it's been in existence. The Latino community needs to show up politically in ways that reflect its true strength. If every Latino in this country showed up to vote, that was eligible to vote, we would not be dealing with this. You would not be listening to a panel from the head of MALDEF or an attorney general talking about suing the President of the United States or trying to find another legal argument to convince people who have been appointed to lifetime appointments on the Supreme Court to stand up and do the right thing. The key message to everyone is one that has to be taken from this room, because quite frankly, I'm assuming if you're in this room, you're already engaged, you're already voting, you're already motivated, you get it. But I'm also sure that if you think through your family, your friends, your community, there's somebody, right? There's a tío, there's a cousin, there's a friend, there's somebody, and you can picture them in your mind's eye right now. Why vote? It doesn't matter. It doesn't make a difference. Tell that to the people of Los Angeles who are running in fear from ICE agents. Tell that to mothers in this country right now who are pregnant and are wondering if their newborn baby is going to have the full right of citizenship. Tell that to anyone who is going to have the rights and obligations of this country, that this country is required to protect and preserve and defend. Tell that to any one of them who is living in fear, not from a foreign government, but from the actions of their own president. It is long past time for the people in our community to show up and vote and act and represent their interests and show that they will not go quietly, that they will not be abused, that they will not be bullied. We will stand and fight. We will use whatever tools we have to show up in court, but nothing that we can do in court compares to the power of this community when it wakes up and shows what it's really capable of. And that's the message you need to take away.
Tom, we have about 60 seconds left, and the last word is over to you.
The judicial branch is essential, and we have to work to change it. But we work to change it through the elections, as the Attorney General has indicated. So it has provided opportunities, but as he said, the lead is passed always to the people, who have to take that lead and run with it and make change. You're sitting in California, my home state, that did change. But in the 1990s, just 30 years ago, this was one of the most restrictive anti-immigrant states in the country. Now that changed because of the passage of an anti-immigrant law called Proposition 187 in 1994. It changed because of the efforts of the people of California in reaction to that and its championing by the government. It was aided by litigation that MALDEF and others engaged in to prevent that proposition from ever taking effect. Would California have flipped had that law taken effect? No way of knowing. But that was the first step. The essential step was what you've already heard, the people organizing and voting to change the state of California permanently. That is a harbinger of what should happen in this country after the Trump administration ends up where it belongs, in the dustbin of history.
Thank you, Tom. Thank you, AG. Thanks, Alba. Thanks, you wonderful LULAC members. We love you. Thanks for being with us.